All right, let's go ahead and get started. So we'll do our usual. Won't be a lot of administrivia. Just a reminder, we're not meeting Wednesday this week. And we will then continue on normal. I know there's some disruption because of the fall break, but we will continue with each class reading that we've got sort of in the lines indicated on the syllabus. That's all the administrivia that I'm aware of. Anything else? Cool. So then moving into where we are and what we're doing. So there are 5 questions in the class. One of them is, each one's as important as the others, but we only get about a day of it. So we had like 2 weeks of formation. And then we more or less get a day of pure formalization. The statute of frauds is the pure formalization moment. And we'll see then, the way this book does it is it tries to also put the bridging concept between formalization and contract terms, which is the Parol evidence rule. That is, what is the relationship between the writing that can serve as our formalization component? What is the relationship between that writing and the actual terms of our agreement? And you'll have already noticed the basic problem, which is, look, if we can come to an agreement with a fist bump, and we've got terms to that agreement, 1 computer, money, dollars, shipment by Wednesday, then, and we've had this long dark night of the soul when Easterbrook starts to give companies online the ability to change that agreement anytime we want. If we just take it seriously, we have that agreement, and then we write it up, you of course begin to see the theoretical possibility that the thing that we write up is very different from the thing that we agreed on, which is almost always the case. And that is the tension that we're looking at. We're looking at the writing as a formalization component. Can it be enforced? But we're also looking at the writing as a guardian of terms. And the way it works is pretty straightforward. We'll do it today just to preview what we're doing. It's essentially, look, before you conclude that writing, under many circumstances, all prior discussions simply just cannot come into court. All that can come into court is the writing itself and, trick for the bar exam, any conversations that happen after the writing. Now, sometimes people will talk about this as the Parol evidence rule as a rule excluding oral evidence. That's parole from legal French. You know, they won the battle in 1066, they get to decide the rules. But it's not just about parole, it's not just about oral evidence. It's about all evidence outside of the contract. That is where we will pick up. I want to give you a chance to ask questions that you have about anything we've done, particularly if you have questions about the statute of frauds in its common law or its Uniform Commercial Code version. That's 2201 under the Uniform Commercial Code, Restatement 110, and others under the common law. And we'll focus on those questions, but then we're going to return to this question of what does it mean to exclude extrinsic evidence of meaning from a document made up of words, because that's not a sentence that anyone should be able to understand because there's no way in which it's true. And that's the tension that we'll deal with today. So, questions you guys have about anything? Yeah, go for it.
Can you quickly go over the exceptions to the UCC statute of frauds?
Absolutely. So first of all, let's just get it under our noses, 2201 of the Uniform Commercial Code. And we'll see the components that we've got. So section 1 sets out our basic requirements. These aren't exceptions. It's just if you don't have them, then you don't have a statute of frauds writing that you need, right? So it needs to be sufficient to let someone know that there is a sale of goods, not a rental of goods. That's Article 2A. Not short-term borrowing. That would be a bailment, right? It has to be for a sale of goods. There has to be a quantity term, and then it has to be signed by the party to be charged. That's not really an exception to the rule, that's just the rule. Subsection 2 then has the merchant-to-merchant exception in it, in which it says, essentially, between merchants, if within a reasonable time, a writing confirming the contract and sufficient against the person who sent it. That means it has to come back and bite them, not just, it doesn't bind the other person. In order to take out your statute of frauds defense under the statute of frauds, I need to give up my statute of frauds defense under the statute of frauds. And what that means is I need to write something that has all of the three elements of part 1, but that apply to me as the sender of this document. That is, it has to be sufficient to indicate that there's a contract for sale of goods. It has to have a quantity term, and it has to be signed by the sender, by me. Trick on the bar exam, they will consider things like email signatures or letterhead to be signatures sometimes. That's funny. Okay, so let's say then that I do send something that is sufficient against me to you, and you are a merchant, and you know that, and you have reason to know that you received it. It's usually on the bar exam. It's an email that sits in your inbox, and you had reason to know it was there even if you never saw it. And then you don't respond within 10 days in writing. That's the other one they'll do on the bar, because they'll want you to know that, like, one party they'll always call the other party up and say, this sucks. Nope. Objection in writing within 10 days, and you will then be able to preserve your statute of frauds defense. If you don't, then sending that missive between merchants, remember, check 2104, make sure the parties are merchants, are acting in their mercantile capacity. If there's an argument that they might be, a law professor going fishing. If I buy a fishing rod, I'm not acting in my mercantile capacity. But if I send that to you and it's got all of the elements between merchants, the writing is sufficient against the sender, and the recipient does not respond in that 10-day period, then they lose their statute of frauds defense too. Basically, both sides get wiped out. It's a way of wiping out the statute of frauds in routine commercial practice, right? We have a deal, one party sends the deal, the other party responds, okay, whatever other fights we're gonna have, we're not gonna have a fight about the statute of frauds. That's the merchant-to-merchant exception. Third, then, is where we begin to get into some of the weeds. So the third has 3 components. And 2 of them, A and C, are just part of what I would consider to be the part performance component of the common law statute of frauds rule. So the easy one to see there is 3C. We are going to waive that statute of frauds, that requirement of a writing, if the goods have been paid for or accepted and received and accepted. That the parties have done all of the performing or a lot of the performing that it looks like you're going to do. Like, you're not going to pay for things if you didn't have a deal. And arguably, you shouldn't accept other people's stuff if it comes to your doorstep if you don't have a deal. A, then, is one we didn't go over, 22013A, is one we didn't go over in great detail in class. I was trying to spare you. It's another version of what I would consider to be part performance. It's the manufacture of custom goods. The idea here is, like, I play a lot of D&D, I play a lot of tabletop gaming, and a friend of mine near DC has got this amazing gaming table. Apparently it was a bit of a Ponzi scheme, and the company collapsed. They took way more orders than they could do, but then the company collapsed. But he was one of the few people who actually got the table. It's amazing, right? Now, look, there are some things there that I think none of you or a few of you would want in a table, right? Like there's little dice trays underneath, right? And there's sort of custom carvings and stuff like that. You can imagine the court saying, look, I don't know if you actually did agree. That's question 1, contract formation. And I don't know what the terms were. That's question 3, formalization. But I'm going to go ahead and say, if somebody starts carving up wood and making this table to your specifications, I'll say that's enough to say we're going to get past the statute of frauds. That's part performance. So that's an element of part performance of goods for custom-made goods. Custom-made goods are a favorite topic of mine in upper-level courses. Of course, you can see why. Can anybody see why custom-made goods are just going to make my evil law professor heart happy? Because?
You have to decide whether it's a good or a service.
Because you have to decide whether it's a good or a service all day long. Makes me so happy. You got it. You got it. Okay. So that's that one. And then the third one that we talked about, so we've now talked about all of our part performance exceptions. The one in the middle is 22013B. That is our judicial admissions exception. If you say the truth in a responsive pleading, you will lose your statute of frauds defense. That is, the one thing the statute of frauds defense should allow you to say is, oh yeah, we totally had a deal. You just didn't get it in writing, so it's not enforceable. That is, legally speaking, the truth. But if you say it in a responsive sworn pleading, you have just admitted to the existence of the contract, and therefore you lose your statute of frauds defense. So enjoy that one. That is our judicial admissions exception. If you state, yes, we had an agreement, in a signed, responsive, sworn pleading, then you have given up your statute of frauds defense. And you can see why, right? Like if you're going to say it under oath that there was an agreement, the court's not going to be like, well, let me ask you a second time, right? Like this is a few good men. Like, you can't handle the truth. Like that's never going to happen on the stand. Yelling at people until they make mistakes is not really a lawyerly thing, right? So the court's just like, yeah, we're going to take your word for it. There was a deal. Any other questions on that? Yep, go ahead.
Well, this is related, but we had a fourth exception I wrote down, like we said 90 plus.
Yeah. Oh, yeah. Well, that's because the question was I should go over the ones that are in the statute. I'm being a jerk. I really despise B&W Glass because B&W Glass adds Restatement 139, makes it up. It's as far as I can tell, the worst statute reader I've ever seen. This judge is like, well, there's a list of things that are exceptions. So you know what that means? It means there are more exceptions than that. That makes my heart hurt. But that's what they did. What they did was detrimental reliance can, if I believed in you, right? That way of launching yourself at a contract, performing before you've got a deal, relying on it, can waive the requirement of a writing to. Now you can start seeing like once detrimental reliance, it can do anything. It can do consideration. It can probably do offer and acceptance. And then now it can do statute of frauds. Like who needs contracts at all? That's why Professor Gilmore was like, having heart palpitations at 3 a.m. and writing books about it. But that is less of a concern today. What you should need to know is there is another exception. It is almost everywhere the law. It will catch judges by surprise because it is bat beeping loco. And it is that one party can say, if I believed in you hard enough, then fairies can be real, and or we don't need a writing for this contract, even though we otherwise needed one. I'll add, that is a rule that is so profoundly dumb that I'll give you a version of it that actually I can get behind, which is the Texas rule. I've mentioned it earlier. The Texas rule is not the rule broadly. I'm just giving you as an example of how this works. The Texas rule says, look, no, if the specific promise is, we have a deal, we do. And then you're like, all right, but we need to write this up. And I say, well, I am a law professor. I will write it up. That's my promise. And you rely on me to write it up. And I don't. And that's why we don't have a writing. Fine. Then you can estop me. Do you see how that works with our early ideas, promissory estoppel? You can estop me because I'm the jerk. You can estop me because the reason we don't have a writing is my fault. I promised we would have a writing and you relied on me, and that's why we don't have it. The Texas rule at least makes me not want to hit things. Whereas B&W Glass just makes me sad inside. It is the law, but holy mackerel, it's dumb. Great question, great follow-up. Love it. Any others? Yep, Justin.
Backtracking to Midwest versus Orion, could you technically apply the parole evidence rule because they specifically stated in the contract that any communication outside of the written agreement is unauthorized?
You could, but what would that do to the set of arguments in Midwest versus Orion? Look, you're pointing to something really important, and it's one that's going to confuse you all. This is why I'm going to say it over and over and over again. With the Ghostbusters, unless there is an emergency, we do not cross the streams. And that's because courts are going to get wildly confused all the time about the first 3 questions we ask in this class. And so will you if you're not careful. Is there a contract? That's question 1. Is there a writing sufficient to get you past the statute of frauds? I didn't ask whether it had the same terms as the original contract, right? I didn't ask a bunch of things. I just said, is there a writing, right, that does that? Third question, what are its terms? What was the argument? What was the defensive argument? That is, what was Orion's argument? Remember Orion. Orion wants out of this, right? What was Orion's argument? Back, yeah.
Fred, basically.
Yeah, well, Fred, except then Fred went into hiding, right? And so what was the result of Fred going into hiding? What was their legal theory of the case? Yeah.
That because they had never actually signed anything, they didn't have a contract.
They did not have a contract. It wasn't a formalization case, except that the court got confused, right? There was a question of was there a contract formed, but then there was a question of could they enforce it past the lack of a writing? And the court kind of smooshed those two questions together, and it doesn't make it really easy. But here's the trick. What you just said is, let's take a look at the parole evidence rule, right? Why don't we just say, hey, the writing said we would exclude all of these side negotiations, right? And because this is what the parole evidence rule and the statute of frauds do together, because they say, this is our agreement and there is no other. This is our contract and there is no other. All that stuff we talked about before, that was just, like us making nice. This is the contract and there is no other. What's the problem if you make that argument? Then you're arguing that there was a contract. So the answer is absolutely yes. Do not give up on that argument. Just realize where it is in our list of questions that we're going to be taking this on, and be aware you just conceded that there would be a contract there, which was the whole thing that they were trying to do, because they were trying to preserve their statute of frauds defense. One reason the court might have gotten a little bit confused about the difference between was there a contract? What fact in Midwest would tell us that there might have been a contract? Give me some facts. Yeah, Fred said, look, we're going to do this.
He actually sent a sample agreement.
Sent a sample agreement saying we're going to, yep.
He said plans for them to build their.
So they're actually doing stuff in response. They're actually beginning to do stuff that looks like performing of the contract. Megan? No, that was Fuqua, but they nearly did. There was this moment where they're like, we can imagine the fist bump, right? They were there like, we're going to go forward with this. We're going to do this, right? Okay, yeah? So he said he was going to go sign it, but then I like the legal terminology here. So dipping, that's a major defense. We'll see that in question 4, defenses, dipping under defenses. All right, so we can see how they really were, we could have made the idea that there was a contract, and that's the argument that Midwest left out of that case, was that no, we actually had a contract. But notice that then Orion was super smart. They stuck to their guns. There was never a contract. 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 Why did they not say, oh yeah, we totally had a deal, but it was for 5 years and you didn't get it in writing?
Because them acknowledging that there is a contract created.
Because that's the judicial admissions exception all over again. So you just have to kind of figure out your way through this maze and not fall into these different pitfalls. But that's why the court, what happened was the litigants in that case smooshed those two questions together because they had to in order to preserve their statute of frauds defense. And that's why the court then had this very confusing opinion saying there was no contract because there is no signed writing, which is flatly false as a matter of law. The fact that there's no signed writing has nothing to do with whether there's a contract. It just simply has to do with whether it's enforceable or not. Okay? Cool questions, y'all. Anything else? Yeah.
Could you reiterate what would constitute a contract of adhesion?
I can. Contracts of adhesion are take it or leave it contracts. Carnival Cruise Line versus Shoot is our core case for it. It's the only time one of the only times a contracts case has actually gotten up to the Supreme Court, because contract law is state law. It's not, it's not federal law. But because that was a case that was in admiralty, it turns out the federal government has control over waters, and so this was an admiralty. They got to see a contracts case. Exciting. But what they did was it's the fine print on the back. It's the boilerplate on the back of a consumer contract. But it's not just the boilerplate that we're used to, because we could have boilerplate between Amazon and one of Amazon's suppliers. That's our battle of the forms. They're swapping that stuff back and forth. This is not just boilerplate on the back, but it's also boilerplate plus take it or leave it. There is no bargain for exchange. There is just simply, you want this, great. If you don't want it, you got to go somewhere else. That's what a contract of adhesion means, that the contract adheres to the deal. You either agree to those terms or you don't enter into the deal. And it also contracts of adhesion become a very rapid part of your defense of unconscionability, which we will see in question 4, right after dipping.
This is a follow-up, just to clarify.
Yeah.
Would an airline ticket be a contract of adhesion?
Sure. I mean, every online contract ever is a contract of adhesion. Every contract we've entered into in this class for the past several months is a contract of adhesion. Every time you see the fine print, they're all contracts of adhesion. They're all take it or leave it. You either accept or you say no to the deal. Yes?
You can defer this question, but why is BW Glass so bad?
Why is BW Glass so bad? Yeah, because among other things, it violates my personal sense of this stuff is confusing enough. And if what we really mean is that y'all need to have a writing for certain important contracts, then y'all need to have a writing for certain important contracts. It just makes it, especially when we get into some of these problems with the parole evidence rule and with these clauses that are in contracts, you'll see they'll all kind of pathetically, desperately say things like, all modifications to this contract must be in writing. Sounds strong, right? Sounds like it would protect your client, right? Let's say that you and I have an agreement that says, as part of it, all modifications of this agreement must be in writing. The problem is, though, we're down at Roadmap Coffee, and we're getting behind a flat white, and you and I suddenly agree, hey, we got to modify this contract like right now. I'm like, well, I don't have a pen, you don't have a pen. Hey, what if we just, check it out, agree to remove that no oral modifications clause? What happens? It's gone. So this stuff is confusing enough. If we're going to rely on writings, it is my personal preference to defend them and to open up the range of cases. But your mileage may vary. If it does, though, I would say we would just need to suspend the statute of frauds for this category of contracts. Because it's ridiculous to say, if I believe in you enough, then we don't need a writing. But ordinarily, in the overwhelming majority of cases, under the UCC, because almost every deal is over $500 now. This used to be a bigger exception, right? Many, many transactions used to be under $500. But now, forget it. If we were to rewrite the thing today, I think it'd be like $5,000 probably, or $10,000 probably. But because of that, it's now gone everywhere. I could see scaling that back. I could see widening the exception from $500 to $5,000. So we just don't need it for nearly as much. But this business where we've got an important contract for the sale of goods and parties are just free to say, oh yeah, we totally had a deal. I know there's no writing, Your Honor, but no, he totally pinky swore. It's the truth, I promise.
Right, even though they had several meetings over the course of a year, but that's still, they didn't come to an agreement.
I mean, we can have several meetings over the course of a year and not agree to buy my house, right? That's the problem. You can meet and not agree.
What's the difference between contracts of adhesion and rolling contracts?
Good. They're often the same. Rolling contracts are less and less of a deal anymore. They're part of Easterbrook's phone thing. A rolling contract is described as money now, terms later. It's a solution to a certain set of self-inflicted legal wounds that Judge Easterbrook dredged up when he just didn't need to do any of this. But he talked himself down that path and then came up with this conception of money now, terms later to do it. The thing is, most contracts of adhesion now aren't money now, terms later. They are specifically click agree, here's the contract right now, and we will charge your credit card, right? So it's moved to this is kind of David's point last time, this is moved to a unified standard, at least online, where all of the terms are. Those are contracts of adhesion. Notice the trick there is you do not have any opportunity to negotiate the terms. They are take it or leave it. So there you can have a rolling contract that is negotiable and therefore not money, that is money now, terms later, but is not a contract of adhesion. You can also have a contract of adhesion that's not money now, terms later, but most contracts that we experience online now are both. They are both take it or leave it. You have no opportunity to negotiate them. And many of them could be characterized as saying, you understand that terms will come later. Or maybe you just didn't read the terms when they put them on the splash screen at first. But at least when you get something extra terms in the box, shipping is where money now, terms later still hits. Because you'll get warranties and extra stuff that you didn't know about. And those will show up in the box. And that still is kind of a money now, terms later deal.
Thank you.
Love it. Yeah, Bailey.
So let's say that I'm an app developer, right, and you're my lawyer, and I want to make sure that I can add different terms later on. I know
Yep.
that stuff
Yep.
right, in the future.
Yep.
How does that relate to a rolling contract? Is it a rolling contract where, okay, like from the very first instance, you enter my site, I click accept, do you have to send another?
See, the thing is, even Easterbrook can't get away with this shit, right? Because if Easterbrook is right, you could just keep rolling the contract. And there would never be a contract formed because you would always anticipate that the parties would change the rules again, right? This is Darth Vader. I'm changing the deal. Pray I do not change it further. I need to get my James Earl Jones impression better. No, they do something different because even Easterbrook has to stop the madness, right? There was a contract at the time we got off the phone. Even Easterbrook, if you push him, has to say that. Then what happens is you get the terms. He's convinced everybody that there's such a thing as money now, terms later. So what he's saying is the consumer knew that for the deal that we had, more terms would be coming. Now, when those more terms do come, though, remember you get the Easterbrook out because he's already talked himself into this corner where you're now being bound to terms you've never seen. So he gets the Easterbrook out, which lets him say, yeah, well, after, I don't know, let me just check under my robes, 15 days or whatever it is, then you're bound to the terms of the contract because you've now had a chance to see the terms. But at that point, it's a done deal. At that point, it's a done deal. Like even Easterbrook wouldn't say, yeah, they can just send you another and another and another. And yet we know that especially with the enshittification of the internet and software as a service and the movement of everything to services and to subscriptions, we know that they do update it all the time. But the way they do it is they just treat it as one master license agreement. And then what they do is they say, well, this is a modification of that agreement. And for a modification, you need to be in writing. So they'll post it to a website saying this is the change in the writing. And then what will they say as a matter of consideration for that modification?
You continue to use the service.
You logged back in. One more breath rule. You logged. Seriously, if you have a dispute, I do a Fairfield video games cases. If you have a dispute with a video game manufacturer and you want to call me about this, and it's better be EVE Online because I don't know why it's going to be worth your money otherwise. They're like, what's that? There is money in EVE Online. I had a guy call me up. He's like, $60,000 went missing. I was like, I hope you find it. So yeah, like with these ongoing license agreements, the trick is you have to have that license on an ongoing basis, or else you're a filthy copyright infringer every time you use the game that you fully bought and paid for. And so it's an ongoing arrangement. They modify it. That modification is fully supported by consideration, theoretically, under this one more breath rule that we've developed in this class, that just by continuing to log into the site or service. And so don't, seriously, if any of you all have crypto accounts and your exchange is going under, this is after the Celsius bankruptcy, this is a big deal right now. And if any of these exchanges start going bankrupt and they change their terms of service, you call me, you do not log the hell in. Because when you log in, you will have accepted the new terms and there will be consideration for the new terms. JetBlue got nailed on this one time. I'm not telling you this because this is the law across the internet. It just helps you see that this law is still here. What they said was, hey, we can change our terms and conditions for our ticket sales anytime we want. Which would be, if that were true, illusory. If that were true, it would be straight up illusory. So there's one case saying, yeah, we noticed that what people are actually doing online, which is online providers are in fact changing these terms anytime they want and binding users to them. That's what's going on here. But they said, you know what, if you state it in that kind of bald-faced manner, yeah, it's illusory because we can just change the terms of our deal anytime we want, right? So what did they do? Well, you can imagine, right? They just made the slightest little fig leaf of cover and they said, well, the consideration for this is that you post the terms, that they have to post the terms online, that they agreed to post the terms online, that they agreed to do something. And because the company agreed to do something, and they didn't say we're going to do nothing, we can change it whenever we want, because they agreed to do something, that was something for something, and therefore that they could make the changes. But you can see yeah, no, that's my expression too. I'm just this is complete bullshit. But again, that's what I meant when I said illusory everywhere. Once you start to see it, you see it everywhere and courts don't buy it, but it's a useful analytical tool for you to see where these deals are starting to break down and how to attack them sometimes. I mean, remains true. If your video game manufacturer screws you over, don't log in, call me. All right, cool. Great questions, y'all. Anything else? Yeah.
This is a midnight question, but if
I know.
Why wouldn't they just use?
I know. Yes. On my exam, you will get many more points using the custom manufacturer exception than you would going with this. I believed in you, which just means I don't need a writing. What the hell? Insane. Yeah, no, far better argument. And there's a number of other better arguments that are listed in the case, and the court's just like, yeah, let me just pass up all this stuff. I want to make up the law. That would be what I want. Cool. Anything else? Yeah.
We've talked a handful of times about how like these cases never actually make it to court anymore because of the arbitration.
Yep. Yep.
Do you think if there were a way that one of these cases did make it into court, it would be overturned, or do you think they would just follow the precedent set by Judge Easterbrook?
I think that they would say they are following Hill versus Gateway, but that they would in fact apply an online one-shot rule now that is slightly different, that says that the terms are the terms made available at the time. I think they probably would still follow Easterbrook if extra terms were sent along with the package. But I think for software downloads and stuff, they're going to move towards the European rule of just the contract is what the parties agreed upon at the point of sale. And you can see that there's some earlier cases. One of them is by Justice Sotomayor when she was still at the appellate level. And she says, like, look, if you bury your contract terms like a bunch of links deep where it's just really hard for people to get, we're not going to automatically bind people to those terms just by coming to your site or service. That's pushing it too far. So there are some absolute, like, sort of successor arguments to Stepsaver, even though Stepsaver is not the law and Hill versus Gateway is overwhelmingly the law. That's a good question. Anything else, y'all? Okay, cool. Then we will move into the parole evidence rule. I'm going to give you a few parole evidence points. For the purposes of the law that we're looking at, the parole evidence rule is a combination of the common law rule, which is in your restatement and your supplement, and then 2202 of the Uniform Commercial Code, which sets out a very testable and very explicit way of looking at it. Now, the reason that I'm mentioning 2202 is because I would like you to see, by the end of this class, the parole evidence rule in two different ways. And one of them is the common law way, and the common law way starts by making sense, but the longer you look at it, the less sense it makes. And then the common law, the UCC rule looks like, I don't know what's going on. But the longer you look at it, the more you're like, oh, I understand this now. Oh, all I have to do is check this box and this box in my analysis, and then I never get anything wrong. Oh, that's amazing. And so I would like you to learn 2202 cold, largely as a criticism of the restatement approach. So that's our sources of law and why we're doing both of them. The parole evidence rule itself is simply when there is a writing, not requiring a writing, that's our statute of frauds requirement. Just says if there is a writing, and that writing is a final written expression of the meaning of the parties, meaning it's an indication of a done deal. It's not us negotiating. It's not us firing Arnold Palmer letter of intent crap back and forth, right? Napkins aren't involved. This is a final written expression of our agreement. If we have a final written expression of our agreement, and we'll add one more thing to it, but the core rule is the terms of a final written agreement cannot be contradicted by extrinsic evidence. I'll say it again. The basic parole evidence rule that sort of burns through everything else is that extrinsic evidence, evidence from outside of the contract, cannot be introduced in court to contradict the terms of a final written agreement. And then the whole fight between Baker versus Bailey and Masterson versus Sine that we're about to get into is, well, what does contradict mean? That's the looseness there. But there's another bit of looseness that I want to tag for you right now because it's a checkbox that is so powerful and so useful that I suggest you do it in the common law as well as the Uniform Commercial Code, where the Uniform Commercial Code sets it out as the gold standard. And that is this. There's one more thing. We can have a final written agreement, but then what we want to say is, we want a clause saying, this is the only deal between us and there are no other terms. Something like that. It's not just an expression of our final written agreement. It's an expression, this is our final written agreement and there's nothing else. Because what that does is that locks down negative space. If I've got terms 1, 2, and 3, and we've agreed on terms 1, 2, and 3, everybody understands you can't introduce evidence that we said not 1, not 2, or not 3 in our pre-contractual negotiations. You can't introduce that because that contradicts 1, 2, or 3. But you can say 4. That doesn't contradict 1, 2, or 3. You can say 5, and here's the problem with numbers. You can say 6, you can say 7. See, there's never a top to those numbers, and that's my problem. The problem is the uncertainties in the contract then scale to infinity without conflict. And courts don't know what to do about that because they're like, look, does it mean that setting a price stops us from talking about other guarantees related to the price? I don't know, neither do you. Certainly the court doesn't. When you draft a contract, lock that crap out. Put what is called an integration clause in. Now this gets called something, you can call it a partially integrated and fully integrated, and we'll talk about that. That's common law crap. What I mean by an integration clause is simply this, a clause that says this is the whole deal and there are no terms between the parties other than those expressed on the face of this document. There are no terms. There are no other deals other than the ones expressed on the face of this document. All right. What that does is that supercharges our core rule. Remember our core rule? Parole evidence rule says you cannot introduce evidence outside the contract from before the time of the making of the contract. Those are our two things. It has to be outside the contract, before the time of making of the contract. You cannot introduce that evidence to contradict any term of this agreement. Well, what happens now if I've got an integration clause and then I try to add term 4? Okay? I can't do it. Why? There are no more. And so you set up our contradiction rule now to contradict infinite negative space. Do you see that? It's really nice. It isn't going to work, and we'll talk about ways around it. But to start with, chef's kiss, really, really good stuff. Okay. There are a few other things that we'll talk about and before we get into the cases, and then I'll just assign people. I'll do my usual and sort of set up 2 people per case, and you'll just go one side, the other side, one side, the other side. And that is this language of full and partial integration. I don't like it. It appears on the bar exam and it appears in courts, so I will tell you what they are talking about. It is also in the restatement. I do not find it useful. So a fully integrated agreement, at least the court has decided that that is an agreement that the parties have reached agreement on all key things and there are no other terms. Whether it says that or not, whether it says it as a term in it or not, the court's deciding under the common law, yeah, this looks complete to me. Looks to me like there's nothing left out. So I'm not going to hear evidence that something was left out. You can see the problem with that though, because there's an infinity of things that are left out. And so unless you have your clause, it's just the court saying things like, well, I had muesli for breakfast, and so this contract looks complete to me. And you're like, yeah, but I had granola for breakfast, and I don't think this contract looks complete. What do we do now, Your Honor? Let's call the whole thing off, right? There's no principled way of solving that problem. That's why I hate the idea of fully integrated. What fully integrated means is the court's about to miss their tea time and doesn't want to hear your shit. That's what fully integrated means. Partially integrated's worse. Partially integrated. Are you flipping kidding me? What this means is that the contract we've agreed on some things in the contract, but not everything. That's called not integrated. Who ordered this for lunch? That's not integration at all. And worse than that, though, what it does mean, and let me try to capture the sense behind why some courts say this is partially integrated. It's because the court is about to miss its golfing tea time and doesn't want to hear a fight about clauses 1, 2, or 3. The things that we didn't agree on, that we didn't have in this agreement, fine, I will hear extrinsic evidence on that. But I am not listening to you tell me that the number 6 equals the number 12. And I say that very intentionally because there is a case in which the number 6 must equal the number 12, and it's a matter of the parole evidence rule, and we will talk about it. It's one of my favorite cases. It's not in this book. But he's like, I'm not listening to this. I'm not listening to this. All right, everybody clear so far before we really start to get into the problem?
Can you go with full integration again?
Sure. Full integration is just the court's decision, whether there is an integration clause or not, that the contract looks fully formed as it is. Looks like we got done what we needed to get done, nothing incredibly obvious missing. And therefore, the court just locks it up and says, looks complete to me, I'm not going to hear extrinsic evidence on it. That's what fully integrated means. I know they give you factors for what's fully integrated. Go look at the restatement. You'll look at those factors and then the veins will start to throb on your forehead. It's just, did the court think this looks complete? Or can you convince the court that something was left out? And that becomes the source of our first problem. How are you going to convince a court that something was left out of a document that looks complete? Extrinsic evidence. Oh no. Oh no. Oh no. And then you get all kinds of problems. Under the common law, many courts will require an integrated agreement to show ambiguity. They will look for ambiguity before they will allow extrinsic evidence. But you don't know whether a term is ambiguous sometimes without extrinsic evidence. And here's one problem. Here's one huge problem. Guess what is admissible? Extrinsic evidence is always admissible for the court to make a determination as to whether or not the contract is fully integrated or not. Now, the jury doesn't get to hear it, but the court does, and you're already going, okay, this whole exercise is intellectually bankrupt. This is nonsense. And there's a deeper reason for why this is nonsense on stilts. I want you to think about what we are saying here. We've got a document. Inside the document are words. Now, your job is to interpret this document with no reference to anything outside the four corners of this document. What's wrong with that picture?
You lose all the context surrounding the words.
Like, where do words get their meaning, y'all? Words don't mean things because we're given their meaning from on high. It's not like, Parol means talking. You know, right? Sprache, that's another one, means talking. It's just a cultural norm determined by its context. We get the meaning of words from its context. And so the problem with this lockdown version of the parole evidence rule is that you can always, here's the thing, you can always explain what the words mean by giving them their general linguistic context, which is extrinsic evidence. Okay, so we've now basically got an impossible ask. We should probably ask ourselves, like, why do courts do this? Just to make sure that we understand. Why are courts so busy locking down contracts and saying, look, if y'all have a final agreement, and specifically, if you have an agreement that looks like it's got everything in it, and you've added one of these integration clauses to it, then you know what? We're going to just interpret the terms of the contract that we've got written here, and we're not going to really take your dark night of the soul about what the meaning of the word is. And I know I'm dating myself by that particular crack. But like the idea that words have, look, anybody want to guess how many definitions there are for the English verb to run? To run a bath, a run of salmon, run in your pantyhose, to run a software program. Anybody guess? 645. There are 645, and that is not counting, and sorry, this is just a moment for one person in the class, that's not even counting the fact that English still uses separable verbs, but they don't teach you. So to run out, to run up, to run out, to run out on, right? To sign on, to sign with, to sign on with. Crap, they're all different. Each one of them's got a completely different set of terms. Now, English is a Germanic language. They don't tell you we still do that. Anyone who studies German is like, oh, this is the end of my life trying to learn these separable verbs. Because every time you add a preposition to the verb changes its meaning. And yet we're supposed to say with a straight face, you can interpret this document without reference to anything outside it. Are you smoking something? That can't be the case. On the other hand, so I need you to see how impossible this is, because that's essentially Justice Traynor, who goes too far. And then there's the other one. Why do courts do this? They're like, look, this is madness. Why do they bar this stuff out? Why do they block their ears? Why are they like, la, 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 I'm just going to look at this document. I'm like, we got to rediscover our sympathy for them.
It ties into the objective theory of like what's on the page and then sanctity of contract and efficiency for the court.
Right, so one, it's got the objective theory of contract. What are we worried about if people just say, oh yeah, I totally meant this. I know what I said. This is what I meant. What's the problem with that picture?
It would get into the, I think it was UCB's in there where they were like, I actually didn't mean to sell you the.
Yeah, so this is the same thing, like we're just undermining the entire objective theory of contract. Why do we follow through on the objective theory of contract? Why do we do that? Why do we not go with what people mean? Because people just make shit up. They'll make up whatever they want. Look, even, by the way, there is no parole evidence rule in European courts under the CISG, the statute on the international sale of goods. Look, an Italian court's still not going to let you sit there and say there was no contract when there's a writing and you've signed it. Like, they're not going to hear this, even when it's the law that they have to listen to the person on the stand blather. They will not go for it. It's not happening. Like, there's a great case called MCC Marble versus Augustino. There's like, no, absolutely not. We are not doing this. So, like, the courts have this sense. We're not letting people just make stuff up to protect the objective theory of the contract. We have to protect the objective manifestations of their words. Full stop. Okay? Cool. All right. That's our problem. We've now set it up. Let's go take a look at a couple of these cases that engage with the desperate need to protect the objective theory of contract and the impossibility of doing that because the terms of words, the meaning of words, are subjectively determined by their community and context. And when we say by their community in contract law, generally we mean their industry and practice context, but it can mean any other context. And the kung fu, the lever that you pull, is just shifting the linguistic context of the meaning of these words until you get the result you want. That's your lever. With me so far? Sweet. All right. Let's set up a couple of these and we'll go through them. Marlene, if you wouldn't mind setting up Baker versus Bailey for me, please.
So the Baileys lived in a mobile home on their daughter's property and drew water from the same pipeline that serviced their daughter's home. At some point, the Baileys' daughter sold their residence to the Bakers, but reserved 1 acre of land surrounding the home for the Baileys to keep. The Bakers and the Baileys entered into a well water agreement to ensure that the Baileys still had access to water. And the agreement was made solely for the Baileys' benefit and was terminated once the Baileys moved. And this was done because the Bakers wanted some control over future occupants, but the agreement didn't exactly say that. And the Baileys understood that the Bakers would supply water to successive owners if they deemed them acceptable. The agreement also gave the Bakers the right to first refusal. And then once the Baileys sought to sell their property, the Bakers informed the Baileys that they would not be transferring water rights to any
Oh no.
owners.
Yeah.
Therefore, the Baileys were forced to sell their property for significantly less than it would be worth if they did have access to water.
Right. Okay. So they're forced to resell it for significantly less, and you maybe wonder whether or not their neighbors are there to try to buy the property once it comes in at this very low value, right? Whether they may be trying to repurchase it. Now that's a standard jerk move, right? What's the black letter law of the case?
That the parole evidence prohibits the admission of extrinsic evidence to alter the terms of the written contract.
That parole evidence rule excludes extrinsic evidence to contradict the written terms of the contract. Okay, do you want to, so I'll ask Jewel to take the other side. Do you want to say that the evidence is excluded, or do you want to say that the evidence should be included? You want to say excluded? So let's turn to Jewel. Do you have an idea as to how you would get this stuff included? First of all, what's the contradiction here? Right? Because what evidence do you want to bring into court? What evidence do you need to get in?
That we had a standards that they would.
Yes, so they had basically a right of first refusal on the occupants, but if they agreed, then they would continue to supply water. That was a verbal agreement that would continue to supply water. What evidence, by the way, in this whole framework gives you your best evidence that, yeah, that probably is what happened? Because the courts, sometimes people are like, oh yeah, we think that words just vanish into the wind and they leave no impression, and we can't really tell whether it's true or not. You've got something you can say here. You're like, no, we know they're lying if they say that they never said that. Can you see where it is? Yeah, we can open it up, yeah.
Is it that right of first refusal? Because why would they have that right of first refusal if they weren't gonna let the new person have water?
Well, why would they have a right of first refusal if they weren't going to let the person have water? More than that, what? Yeah.
I think the bakers specifically didn't want any hippies moving.
Right. Okay. So we're going to get into the questionable politics involved here. I will not make hippie jokes. Will not make hippie jokes. Fine. They didn't want hippies moving in next door.
They got it appraised with water rights.
Okay. There it is. Right. The price they paid up front, the fact that they resold it for a lot less. You buy at this price with water. You sell at this price with no water. Everybody is clear you thought you were buying it with water. And the whole idea is like, oh, no, you were buying it with water, but you can't sell it to anyone else with water. Okay, we don't like that's such a dumb statement. We don't even need to get into it, right? So there's like really good evidence here that that this probably happened. All right, so now you've got a little wind under your wings. You're like, look, Your Honor, in fact, there's a parallel case in another jurisdiction where the court like drops the hammer on the person who pulls this stunt, saying, because what they did was they actively went and rebought the property after depriving the water rights. They're like, killed the water, they took the first check for the property, killed the water rights, forced the resale and bought it back at a lower cut. And the court's like, you're getting paid twice. I am angry now. Right? So there's like some wind under the court's wings. I get it, that's not how this case goes. We'll be back with Marlene on like how that's going to work. But what do you then say to try to get this in? You have confidence now it happened. How are you going to get this in past the parole evidence rule?
We would bring up the appraisal, and then I would probably argue that like the meaning of the meaning set out in the water well use agreement was so that if there was to reflect that they would provide water for a reasonable buyer.
Okay, everybody see the argument that's being made here. I am not bringing in extrinsic evidence from outside of this contract. I am explaining the meaning of the terms in the contract. The terms of the contract, its price, the right of first refusal, and other elements, none of them make sense without this linguistic context. Got a response to that?
I would just say that the agreement is like explicit in saying that the agreement is solely for the benefit of the Baileys and should terminate when they move out.
Okay, so the agreement's solely for the benefit of the Baileys and terminates when they move out. What's your response to that?
Could you not push back and say that that agreement would only terminate for the Baileys, but that it could be re-upped for like the next person?
Right, see what you're doing? This is great. What you're doing here is you're saying, look, no, you're giving me this specific point, but my argument doesn't directly contradict your point at all. Both could be true. You could have agreed our agreement could terminate when we leave, and you could agree to provide water to somebody else, and that's perfectly consistent. Marlene, what's your response to that? This idea that anything you say, see, because now Jules like got this amazing tool. Anything you say, she just narrows it down to what you're saying, and she's like, yeah, but I'm over here. I'm not saying exactly what you said. I'm saying something slightly different, and that doesn't contradict.
I mean, I would just still say that it's clear and unambiguous.
Yeah, and you're going to win on that ground. Like when you have a court that seems to be like this court, deeply into the parole evidence rule and states it in that kind of conclusory fashion, right? Yeah, you can just say this is clear, it's unambiguous on its face, this was the terms of the parties, the term that they're relying on is simply not in it. And so that's your strongest set of arguments. It carries you a long way. But also this is the argument that then starts to run into trouble in Masterson versus Sine, although I think that case is insane on other grounds. But the idea here is, how are you going to get past this Sure, it's a yes and, right? It's the comedy rule, yes and. You're saying this terminates with the Baileys. She's saying, yeah, but that doesn't mean you didn't make representation about the terms of deals with other people.
Wait, sorry, could you repeat the question?
Sure. So your argument is the deal's clear between us and the Baileys, right? And this term is not in it. That's why you're clear, unambiguous, and it terminates when we're done. That makes sense. Fine. Therefore, you're saying that contradicts this water promise if the people who move in aren't hippies, right? But it doesn't contradict it, says Jewel, because the water promise, if somebody else moves in, is a part of a different deal, is a part of a different arrangement. This is a really common set of arguments. Any argument about that? We're getting into the hard stuff. I realize we've now moved from like the stuff that law students learn to the stuff that lawyers do. Yeah, so let's try. There's a really famous case about this. It's about an ice house. So like my grandparents lived in Frog Hollow up in Singer's Glen, north of Harrisonburg. And they had a house on one side of the road, but then there was an ice house on the other side of the road. Now in this famous case, what happened was there was a deal to buy the house, and the fight was whether or not it was going to include the ice house or not. How would you fight that? How would you say the deal to buy the house clearly involves the ice house? Yeah.
It was so important that it should have been in there.
There it is. That's the argument. Exactly. That if the term is one, here's how courts say it. Here's how courts say it. The term is one of which would be so central to the agreement that if the parties had intended to include it, they would have included it. And that gets you out of this constant game of whack-a-mole where any term you assert, right, Jewel says, well, no, what I'm trying to prove, the extrinsic evidence I'm trying to prove is actually something different from the term. No kidding. That's why you're trying to bring in extrinsic evidence to contradict the terms of the contract, because you're trying to get term potato turned into term potato. I get that's what you're doing, but you can see that how a narrow interpretation of the contradiction requirement can really leave the person relying on the parole evidence rule at a bit of a loss, because there's never really a contradiction until you start saying, no, look, if we'd have meant that, we would have said it. That is so integral to the deal. If we'd have meant that, we would have said it. Any final pushback, Jewel? If we would have meant that, we would have said it.
Explicitly not say it.
What's that? One, they didn't explicitly not say it. And two, you might say with some frustration, Your Honor, they did. This is the entire point that we're making. They didn't include it in the writing, but they absolutely did express it, and we can tell through the prices that this was the deal. Look, if this seems muddy, it's because it is. It's because courts have asked us to do something impossible, which is to cut down on their work and interpretive load by restricting their interpretive universe. But the problem is you can't, because every clause in a contract draws on two things: the community and context of the people who negotiated the agreement and the context of the contract. And they draw on the community and context of lawyers interpreting those agreements. And those two layers let us change the meanings of the terms from inside. It's like that horror story, right? The call is coming from inside the house. You're always able to change this stuff. If you want to know who's right, what am I going to say? Who's paying me? Yep, who's paying me? Okay. Any questions on Baker versus Bailey? Yeah.
If you can choose to not answer this, but if it wasn't a mobile home and it was a regular home that they built on that
Yep.
with actual pipes in the ground,
Yep.
and at that point would that just cross out this agreement?
No, but it would really give Jewel ammo. She already had ammo through the price and through the structure of the contract. It was clear. Look, y'all, it was very clear they had this price guarantee. There's no question they had it, right? The pipes would just make that even more clear, but there's nothing legally speaking that says water must flow through those pipes. I mean, when we get to property law, by the way, you will find, though, that the property rules around this cut in the way of your intuition. If I'm running water through your property and you see me doing it and you in fact induce me to rely on it, and yeah, it starts to sound exactly like estoppel. It is in fact a different kind of estoppel, but it's the same argument. You let me do it. You let me do it for long enough. You now can't stop me from doing it. So with property disputes like this, you actually do run into legal rules that capture what you're talking about. We just do it as a matter of property law rather than as contract law. That's a great question. All right, any further ones on Baker versus Bailey? Yeah.
Is there any way you can make an argument that they said that they tried to find other sources of water but were unable to? So does that bring up any aspect of like an unconscionable argument at all? Like they're kind of entrapping them to stay.
Oh yeah, no, and it was an unconscionability style case in which there's another case in another case book in which they pull pretty much the same stunt, only it turns out that the people had been paying on a land sale contract where the seller had kept the deed, and you were only going to give the deed to the buyer once the last payment was made. And then the seller basically like forces the buyer to default so that the seller can like take the whole thing back. And the court's like, okay, no, we're going to convert that into a mortgage. We'll just call that a mortgage, and that gives them a right of equitable redemption. So yeah, courts do get pretty sarcastic about those splits. It's a great point. All right, cool, yeah.
So could you make an argument, like rather than trying to say that the right to transfer was some oral agreement and you want to integrate it into the water use contract, could you just say that it was a separate contract?
Yes,
altogether?
and that's, we were doing so well and I wanted to stop you on a high point, but I didn't want to pretend like the carousel was going to quit, right? So you say things like, oh, well, yeah, so if this term was so important to the deal, then why didn't we include it? And it was critical to the deal, therefore that's evidence that the parties, if they had intended to include it, would have included it. But all you got to do to push back on that is say, no, Your Honor, like we clearly intended this to be a separate deal. And it is a separate deal. It was a separate oral deal. And the nice part about that is that the parole evidence rule for deal 1 doesn't block all this discussion about deal 2. It's just a different deal. And so you're saying, no, it's the same deal, you just left that out. And you're saying, no, it's just 2 different deals. The carousel never stops. It's a brilliant point. All right? Questions? Any further? Yeah.
I was just wondering, if they did include that language, we will transfer the rights to the next owner if the Bakers like them.
Yep.
Doesn't that make it a bit illusory on its face? Because then the Bakers have the ability to just dislike anyone who buys it.
Yeah, but remember, not every option is illusory on its face if you've gotten something for it.
I see.
Like, for example, if I give you a right of first refusal in return for, I don't know, water, then maybe that is an option fully supported by consideration. If I have an option to buy stock in 1 week at a certain price and I pay somebody $5,000 for it, the fact that I have that option down the road doesn't make it illusory. The exchange was already there. It was already something for something. Yes, if there was nothing in return for it, then that arguably could have been illusory. But the thing is, this is already a big damn deal with a bunch of different moving parts. And so it's really easy to say part A over here was in response for part, like almost anything, like A, B, C, or D, or E. They're all perfectly good consideration for any promise you make in F. Does that make sense? Yeah. Great question, Bailey.
Couldn't you just make the argument, I'm pulling it from Masterson versus Sun here, but couldn't you just make the argument that A, water is a movable good and it falls under the UCC, and that in the comment 3 to the 2202 that you could argue that there was like, what is it? It says the judge may need evidence explaining the offered term.
Oh.
Practices on comprehensive and writings and the reasons for exclusion of the term.
All right, 1, aggressive legal argumentation. I love it. I'm here for it. 2, yeah, there's a lot to be said here. Because if we move, what does it get us to move a court case from the common law to the UCC? Well, here's what it gets us. The UCC, remember, is the dark side of the force. Quicker, easier, more seductive, moves faster, and fills gaps from where? Where does it fill gaps from? You heard it.
No, sorry, I was thinking about something else. This is, I was thinking about water rights laws. This is prior appropriation, not.
Yeah. Where is, what, right, yep. Industry custom and practice. It's huge on industry custom and practice. In fact, you can see there are rules on industry custom and practice that are incredibly strong. And one of the places you see them is in 2202. Take a look at it. 2202. terms with respect to which the confirmatory memoranda of the parties agree, this is 2202, comma, or which are otherwise set forth in a recording intended by the parties as a final expression of their agreement. We're going to stop there for a second. Why would they say two things here at the outset? One, final written expression. We're familiar with final written expression. But two, where can we not have a final written expression but have terms of memoranda agree? We have no contract on the writings. We're in the UCC now.
Course of performance?
Course of performance, that is Uniform Commercial Code 22073, contract by conduct. Remember, we don't have a contract on the writings. There is no final written expression, right? I said potato, you said potato, I shipped it, you paid for it, now what? Right? That's where we get that. So that has one additional weirdness they have to take into effect. We're now doing contracts by conduct. Contracts by conduct. And we capture those in the first part of the rule. So now we read, terms with respect to which the confirmatory memoranda of the parties agree, and not terms with which they do not, or which are otherwise set forth in a writing intended as a final expression of their agreement, may not be contradicted by evidence of any prior agreement or of a contemporaneous oral agreement, that's the same time oral agreement, but, and here's Bailey's point, may be explained or supplemented. So the UCC just opens the door. They just say may be explained or supplemented by what? By course of performance, course of dealing, or trade usage. I'm going to tell you what these words mean right now. Write it down. Course of performance means we have a long-term contract. It's what we did last month. That's course of performance. Course of dealing is this. We've had a series of contracts. This is the contract, the different contract, but with similar terms that we did last month. And this is how we did it. And then trade usage is how does our industry do it? And what this boils down to is you can almost always crack open a contract under the UCC if what you are trying to tell the party about is course of performance, course of dealing, or trade usage. You can almost always, and this is the reason why we do Bailey's move here, why we're going to try to get this under the UCC. If this is locked up under the Four Corners rule, under the common law, and we can kick it open to the UCC, we can start saying things, Jewel can start saying things like, wait, I've never heard of the sale of land without water, residential property without water access. That is not what do you see the difference? That's not what the parties said. That's not extrinsic evidence of what the parties said. Right? It's extrinsic evidence of the industry custom and practice that gives the words meaning. And you can pretty much always crack open a UCC contract and explain with course of performance, course of dealing, or trade usage. Literally, it's what did we do before in this contract? What did we do before in similar contracts? Or what does our industry do? And you can say those three things with a straight face all day long, including, by the way, what is course of dealing in this case? If we split up these two contracts, right? There's contract one, water for this residence, and then we're considering the question of whether they can leave that term out of contract two, water for the new buyer.
So this is stupidly specific, but because I know this is prior appropriation, I know you can sell houses with water rights for only a certain number of years.
Yep.
So is water considered a movable good?
Water is considered a movable good under the UCC, yeah. But the appropriations rules don't consider it to be the sale of water. You're using the law of capture to take water out of the environment, but you're not buying it. That's how those two rules interact. Yeah.
Sorry, just to go off the point of the Madison case, couldn't you also say it'd be a naturally made subsequent agreement?
Right, so this is the idea is if it's a subsequent agreement, then you might, under the UCC, you'd say something like course of dealing. You gave water last time. Course of dealing might say you probably intended to give water this time. And that we can get that in past the parole evidence rule, because it's not what the parties said before they signed the deal. It's just what the industry said, or what you said last time you did this. All right? This is an incredibly powerful rule. It's one that gives high-level attorneys the absolute heart palpitations. I'll give you an example of how powerful this move to the UCC is. This is the big difference between the common law and the UCC. This is it, which is that the UCC just loves course of dealing, course of performance, and trade usage, and will just allow them right in past the parole evidence rule. And here's how powerful it gets. In one of my favorite cases, not in this book, a company with a lot of guts and probably no sense agreed with the city of Chicago to provide rat traps. Now, they were the lowest bidder in an auctioning process, and their bid was about half what it would have been in any other agreement. And they were supposed to provide a certain number of rat traps. Now, the reason why we'll say the number 12 here and 24 is because these rat traps came in boxes of 12. But of course, what the company who underbid everybody else did to get the low bid was they opened up those packets, each of which had 2 glue boards in them to catch the rats. And so they were able to underbid everybody else by saying, we are delivering 20 boxes we're delivering boxes of 12, where they were just literally delivering just 12 glue boards instead of delivering 12 packets of glue boards, which would equal 24. The court, first of all, to be clear, the numbers were absolutely certain on the contract as to how many were supposed to be provided, how many units were supposed to be provided. And Rages, the bad guys, they provided that number of units. And the court was like, yeah, but industry standard, these things come in packs of 2. I'm going to crack open the number 12, explain it by industry custom and practice, and show you that it really means 24. Because the company that makes all of these glue boards, and there was only one company, an industry made of one company, y'all, this is some lever work. This is some lever work. This is a lawyer going, oh, check this out. I can get this passed, by pointing to this one company and their practice was to package the glue boards in sets of 2, and that was an industry custom and practice. And so that's what got in past the parole evidence rule. Literally, they got extrinsic evidence into court saying, nah, 12 as a number is ambiguous and really means 24. That explains to you how powerful Bailey's move here is. Right, is to get this swapped out so that you can use these 3 categories that almost always get passed. By the way, if you're worried about this by this point, and there are some big cases up there, as a practice tip, I will tell you what to do. Here's the problem. The problem is, let's say you know that there's an industry custom and practice, and you do not want to follow it in your particular transaction. You have to name it and shame it. You have to say, we are aware that it is the industry's custom and practice to package these glue boards in sets of 2. We are not following that practice in this contract. We are following a practice that each unit is 1. And you can see then why that would prohibit the extra evidence from coming in, because that would contradict what you just said to name or shame the industry custom and practice. Otherwise, it's a super powerful move. It's one of the most powerful moves attorneys get handed. It's just a free way in past the parole evidence rule. It's a gaping security flaw in the parole evidence rule. Questions on that little side? What we did was a little bit of a side move here into the UCC and showed you why the UCC is different. Cool. All right, let's move in then to Masterson versus Sign, where we're going to get the other side of this. And Gracie, would you mind setting it up for me, please?
Sure. The Mastersons owned a ranch and deeded it to their family to sign. But the deed had options for the Mastersons to buy the ranch back within a certain amount of time for the same consideration of being paid heretofore plus their depreciation value of any improvements. And granted may add to the property from after 2.5 years from the state. And that Masterson ended up bankrupt, and his bankrupt trustee wants to establish the right to use the option. And is there a reason why the wife is in the suit too with the trustee?
Oh, this is so good. There is something so wacky going on. I cannot figure this case out for the life of me. First of all, Judge Traynor, titan of the industry, but man, the man's never met a contract he doesn't want to break up. What is going on here? First of all, what is going on here with this idea that the repurchase option, what do they argue about the repurchase option? Why can't the bankruptcy trustee use it? Because this takes a little bit of unpacking here to figure out what the hell's going on in this case.
They're arguing that the bankruptcy option can't be transferred because it was intended to stay inside the family.
Because it was intended to stay inside the family. I mean, how do I even do this, y'all? Look, you're going to have you're going to have a client, and they're going to come in and they're going to say, hey, I just want to do a consultation with you. I'm not really worried about that. I'm not all that worried. One, I'd ask ChatGPT, and ChatGPT says I'm fine. And two, by the way, it doesn't even matter. Like some guy just sent me a lawsuit and says I'm being sued, but it doesn't matter because when I figured out that I was being sued, what I did was I transferred all of my property to my cousin Fred. He's back. You know what the court's going to do with this, right? Like I'd already see it. What's the court going to do with this? Yeah, they're going to be like, what the hell? That's called and to be clear, I'm telling you this, one, as a matter of contract law, two, to preserve your license. That's called a fraudulent transfer. The court is going to, like, sometimes attorneys think they're like, I'm just built different. Like, I've thought of something nobody's ever thought of before. And they try this shit, and the court's like, yeah, it's Wednesday. I've seen this, 30 times by Wednesday. Are you even kidding me? And so, it's a fraudulent transfer. The court is going to unroll that so fast, there's nothing but a blur. Right? So you have to ask yourself what kind of weirdness is going on. I don't know that I've got an answer. Usually I have an answer for why trainers working so hard to manage this thing. It might be some sort of Grapes of Wrath stuff. If you've read John Steinbeck's Grapes of Wrath, right, there's this great legal moment where the topsoil is being blown away and the whole dust bowl is being destroyed. And there's even reference to how when people would go bankrupt during that period of time, the banks would show up and try to auction off the property. And anyone who would show up and try to bid on it would actually just be beaten up by the farmers who would otherwise just pack the room out and stay silent until the price got to like $1. And then the guy who owned the place would buy it. And all of the farmers were like, is anybody else bidding? I didn't think anybody else was bidding, right? So maybe that's what's going on here. Maybe there's some sort of meltdown that trainer really wants to protect this family farm. I don't know what's going on here. What I do want to tell you is this shit should not work, right? This business of offloading your stuff to a family member because you know you're about to go under and then you're going to repurchase it from them after the bankruptcy. Are you freaking kidding me? And never mind the fact that it's an obvious fraud on the court. Also, it's just straight up against the bankruptcy rules. When a person comes in and serves as the debtor in possession for a bankrupt entity, their definition is that they have all legal rights and powers of the person who they're standing in the shoes of. That's the definition of the trustee. So I don't know what trainer's doing. Usually I have a clever thing explaining why that's the case. I just didn't want you to read this and be like, fraud on the court. It worked in Masterson versus Sign. Like, no, absolutely not. Okay, so now that we know this crap, which side do you want? Do you want this in, or do you want this as an extra term that's we can hear about in court, or do you want it to be something that was so important, it would have been part of the deal, and therefore if we had intended it to be part of the deal, it would have been in there, and so we're going to exclude it. Which one do you want, exclude or include? Exclude. Okay, you want exclude. Fantastic. That is awesome. And Megan, if you wouldn't mind taking the include run then. So we'll start with include then, because the case is an include case, right, to bring it in.
So the contract is pretty unclear, some of the meanings, and I think we need to clarify.
So I love that we're starting. The contract meanings are unclear, and we need to clarify them, right? Gracie, what's your response to that? The meanings of the terms of the contract are unclear, and we need to clarify them.
I'm sorry, I can't think right now for some reason.
Okay, it's no worries. Let's open it up to co-counsel. What do we say about the meanings of the words are unclear? Yeah, Gene. Nuh-uh. First, yeah. Oh, that's a dangerous pen. Yeah. Dangerous pen. This reminds me of lobbyists. I won't go on a tangent. It reminds me of lobbyists in the privacy industry who say, well, we can't give you privacy because we don't, this is true. They said, there's this big initiative saying, do not track. So if you set do not track in your browser, the idea was that they wouldn't track you. And they got out of it by saying, yeah, but we just can't decide what track means. Like we just have this sudden, just complete inability to determine what the word track means. It's like, well, how about you just don't do anything that might be tracking? Let's try that. What's the problem here with saying words are ambiguous. Therefore, I need to be able to reach outside of the terms of the contract.
I feel like that's kind of gambling.
Yeah, right? It's just, like, if that's true of that, like, here, let's try this. I am a little bit of a linguistics junkie, speak a couple of languages, huge into philosophy of language. Give me a word that I can't give you multiple definitions of. I'll wait. That's what I thought. There's no such thing. Like, again, as the guy said, depends on what the meaning of the word is. Who knows? So the problem is it goes too far, and at that point you're just rolling the dice. So do we have any rules then that might constrain the idea that, well, we can say anything because any word could have a million meanings, and so we can always just bring in some meaning? Yeah.
Reasonable interpretation.
Right, so we start with reasonable interpretation. How, by the way, are you going to constrain reasonable interpretation? Which Judge Traynor does not do in this case? How do you constrain, like if you were to actually do reasonable interpretation, we have to figure out what the word, and I'm deadly serious about this. This is why my exam is for this semester and not for future semesters probably, because this is going up on YouTube. But for this semester, it is AI proof. Because on my exam, when you talk about Fred, what's Fred mean? And how did we find out? Use methods of reasonable interpretation.
Like the colloquialism inside the classroom?
Yeah, so you establish a community, right? This class, right? And then you look at how they use the words within that community. So its meaning is used within a context and a community. The context is a class, the law class, the community is a bunch of law students. We are using the word Fred as a way of describing a set of opportunistic moves that parties make by playing games with who is deemed to have the capacity to enter into a contract. We're playing whack-a-mole with legal entities in order to avoid liability. That's what it means. We did it here. All right. Is that what Traynor's doing? What's his community of meaning? He doesn't say law class, classroom. What's his deal? What's he think? Yeah.
Well, he basically adds, the contract was, the deed was silent on the question of assignability.
Yeah.
He just throws it in there.
He's just like, look, it didn't say anything, therefore it doesn't contradict the terms. See that move? Again, it doesn't contradict the terms because it was silent. It doesn't contradict the terms that it was silent. And Nick, your response to that, if it doesn't contradict the terms because it was silent, will be what?
So important it should be in there?
Yeah, it's so important it should, like it was silent. Among other things, let's be clear, a term that if they had included would have been fraud on the court and would have been railroaded by the trustee in bankruptcy so fast that there would be nothing but a blur. Seems like the kind of term, if you'd have meant it, you'd have put it in there. All right? So we've got this, again, what does it mean to contradict? And I want everybody to see Justice Traynor's move. Because what does he do then? Because you're going to win this one, right? You're going to win this one in this case. What's he do with this idea that then we've got, it's silent, so I can go ahead and talk about it. And not only that, this restriction on the repurchase option, where it says it was only meant to be a fraud on the court. Sorry, it was only meant to go to a family member. It wasn't meant to go to the trustee in bankruptcy. I still don't understand how Traynor can say this with a straight face. That element doesn't contradict anything in the text.
I guess he's defining the community of meaning as the family, and that agreement occurred outside of the written, but I'm not sure.
Yeah, so he might be looking at the community of meaning of the family. The difficulty with that, of course, is that as a matter of parole evidence, that's exactly the parties' negotiations prior to the writing are exactly what you're supposed to exclude, even though we still do provide contextual cues as to what it was supposed to mean. Lucas, yeah?
I think he also says that this case is one therefore which can be said that a collateral agreement such as the alleged might naturally be made a separate agreement.
So this is our ice house case again. It's natural. If we have a deal for the house, it's natural to say that there might be a side deal, and that the side deal would have its own ups and downs, right? So that's another one. He's using all the tools we developed. There's another tool he's using. Does anybody notice what he does with contradiction, what he lets in? What does he let in? Do we think Traynor would let anything in? And by the way, the sarcastic answer and my answer is yeah, actually. But do we think, like, beyond my sort of sarcasm, do we think he's going to let everything in, anything in? Give me an example he wouldn't let in. Yeah. Well, that contradict, is he going to say that they contradict unwritten terms? Yeah. They have to be not, oh my Lord, I love that. That's called latotic, right? That double negative, not inconsistent. Are you freaking kidding me? What he does is he defines contradiction down to a point, to a single point, where what he's going to say is you have to say yes, this fact, and they have to say no, that exact fact. Let's try it. You want to buy my truck for $750. I know you do. And then my response is, oh, but I want to introduce oral evidence that we, in fact, agreed on $1,000. Do those two numbers contradict under the Trainer analysis? Right? Of course they contradict in terms of real life, right? The establishment of one price precludes the establishment of another. But the two numbers are different. They're not like, one party didn't say, it was $750, and the other party was like, it's not $750. You see what he's doing? He's restricting contradiction to such a narrow band that it loses any meaning, instead of getting to this kind of conceptual contradiction of a different price within a range. Okay, so those are his moves. You notice then the black letter law of Masterson versus Sign, which is essentially, we will let anything in that helps us explain the terms, that helps us explain what we're looking at in this agreement. I want to hear anything that will let us help determine the words of this agreement, which, if you realize what we've been doing all along, means we have no parole evidence rule anymore. And that's what Masterson versus Sign is doing in the book. It's showing you how you can use these arguments to essentially fade the parole evidence rule into non-existence, especially in California. You cannot get away with this stuff in New York. New York and California are, for the bar exam, taken as two opposing sides of this picture. There is the four corners rule of New York. It's got its own problems. How are you going to crack those four corners rules? One, turning you to UCC is great. Lovely move. If you don't have access to the UCC, how are you going to get inside that document? Go ahead.
Partially integrated.
You could argue that it's partially integrated. If it doesn't have a full integration clause, you can say it left some stuff out. But again, four corners, right? It's going to say this is the whole deal. New York is hardcore, right? How else are you going to get out? Yep.
Say that the facts don't contradict the evidence, they just add context.
They add context. That is, I am not adding evidence from the outside of the agreement. I am telling you what the words in the four corners mean. The phone call is coming from inside the house. So it's that illusion that we are not bringing in extrinsic evidence, we are merely bringing in linguistic context to tell you what the words of the document mean. That's how you're going to crack that one. And then you go to Masterson versus Sign, and you see the opposite, and Justice Trainer represents sort of a far mark. I don't think I've ever seen another case that goes quite that far, where he's like, yeah, I love frauds on the court. Let's go ahead and permit this crazy clause that makes no sense to anybody except for somebody who's trying to defraud a bankruptcy process. And we're going to do this through this weird thing which says there's a repurchase option, but somehow the legal representative of the debtor is not allowed to exercise that repurchase option because that would stop our ability to do an onside kick with the ranch and defraud the court. That is such a bizarre set of circumstances. I don't think I've ever seen anything. Do not take Masterson versus Sign, and in fact, do not take the four corners rule of New York seriously. Almost every case that you're going to be dealing with is going to be operating between one or the other. And if you ask me whether I'd take money to make a four corners argument and say, Your Honor, as co-counsel has already indicated, this is an important term and it would be part of the contract if the parties had intended, I will take money all day to do that. And if you then want me to turn around and say, Your Honor, this actually is such a different term that it actually relates to a different transaction, which has nothing to do with this writing, and therefore evidence of its making can be entered into court. Again, we'll just do that all day long. Any questions on this? Yeah.
He makes like a point where it's like the fact finder is likely to be misled. But isn't that why they exclude?
Yes. Look, you're not going to get me to agree with Trainer. It's a nightmare of a case. But the whole reason is so that they don't get misled by, as Scott pointed out, by people making stuff up. including, by the way, to be very clear, this particular option, which has been made up after a procedural move in order to save a fraud on the court. It's so clearly made up. It's so ridiculous. All right. Any further questions on this one before we move on? Okay. So what we've done is we've established two ranges, right? It says here in the middle of page 293, try to reconcile this decision with Baker versus Bailey. Do not try to reconcile this decision with Baker versus Bailey. You will either succeed or you will fail. If you fail, you will feel like you've done something wrong when you've in fact done something right. And if you succeed, you should have your head checked. Because they're just like, they're obvious opposites. And what they do is they show you the sets of arguments that crack this open or lock it down tight. That's what you're looking for. You're not looking for consistency at all. The two cases are there to show you the inconsistency. All right? Cool. We did talk already about the Parol evidence rule of 2202. That's on page 294. What I will, I'm happy to take questions about it. What I would strongly encourage you to do, this is going to be a really rich area, for you to go find split, is it common law or is it UCC questions on my prior exams, and then try to figure out what the Parol evidence rule part of it is. You'll often find, it's a split between two. In fact, I was just talking with some folks earlier today about one of them. There's a split between the two, and arguably the dollar figure of the contract was over $500, and so you would need a writing, and there would be a statute of frauds question, and therefore a parole evidence question, if you put it under the UCC, but if you put it under the common law, you wouldn't need it because the contract could be performed in under a year, and so you wouldn't need the writing at all, and none of this stuff would start happening. So just go look at a couple of those and add to your question these three issues. And these three issues pour into our core first three questions. For the UCC, it's easy, right? Was there a contract? That's going to be 2206 and 2207. Was it formalized? That's 2201. If there was a deal and there was later written up, can you prove the terms of the original deal past that wall of the writing, of the thing that was written up? That's going to be 2202, your parole evidence rule. And we've also done then, in just a few seconds, formation, formalization, and terms, which is what we have begun doing, right? Parole evidence is half formalization and it's half terms. And we're now moving firmly into terms. Are there any questions before we leave formalization and start talking about interpretation, which is a weird one to do. It's why we had to kind of start with parole evidence, because that's the only place that interpretation has any bite. Otherwise, frankly, I'm just going to come straight back to you and be like, how do you interpret contract terms? I'll ask you in a moment, but you already have the answer, so we're going to be good. Any questions on anything we've got up through parole evidence before we do another gear shift? We are about to leave formalization behind. 2201 is the statute of frauds under the UCC. That is formalization. And 2202 deals with the interaction between that and the terms, which is why the parole evidence rule sits sort of uncomfortably in between our formalization part and our interpretation part. Yeah.
You can, if this is too complex, you can leave it for afterwards. But I am just so genuinely confused about the note with Hunt versus Doliner, and then
what page?
Basically, page 295, and the fact that they basically reject Hunt's view and hold the latter view of inconsistency. I'm talking about like inconsistency, just in general.
Yeah, the only thing I want you to take away from that is that inconsistency or consistency is a lever. Contradiction is a lever. I don't expect you to know Hunt, or I do expect you to know Baker versus Bailey and Masterson versus Sine. But where they're playing games with what is inconsistent and what is not, I need you to play the game, not give me the answer. And I've seen it, one price is clearly one price is inconsistent with another price, right? Like $1,000 is inconsistent with $1,500. But I've seen cases where they're like, yeah, so the price is $1,000, but if you can get it for less than $1,000 from someone else, I will give you a lower price guarantee. And the court was like, sure. And the one side was like, wait, we just said a lower price was inconsistent with the price we set. How can that be? And the other side was like, no, a lower price guarantee if you find something else is just an additional term to the contract, and therefore it's not inconsistent with the terms in the written agreement. I need you to play that game. I do not need you to find a resting place for your mind on it, to believe in any one position. I don't want you to believe in any one position. I want you to be able to move the lever. Okay. Cool. All right. Interpreting the terms of the contract. Look, here's the problem. They give us a few cases. This is the most frustrating to me section of the class because this is what I started with. Like, I was like, how the hell do you teach a class about contract law? Because what is the actual law between the parties once they sign a contract? Whatever the hell they just said. And then you're like, well, what do I do to interpret that? What do I do to interpret that? Yeah, which by the way is, to be clear, nowhere found in any of the case law. What I'm talking to you about actually comes from the law, from philosophy of language. How do words generate their meaning? And the answer is they draw their meaning from context and community. That's how they draw their meaning. And so you can shift their meaning by shifting their context and by shifting the relevant community. I'll show you. There was a case I think I've already mentioned earlier about a statute where the question, you don't need to know the statute, it's intellectual property. The question was, is this product a household name? Because if it is a household name, then it got protection under what was called trademark dilution. You can't make Nike pianos because Nike's famous, it's a household name. And so people would think, a Nike piano? Nike's making pianos now? That's crazy. Whereas if you said like, Fairfield pianos, even if I had it trademarked for my consulting business, which, like I do, but even though I'm not a household name, and so you could have Fairfield pianos, that's fine. That's the backdrop here. The court's question was, whether or not this product that they were looking at was a household name. How do you think the attorneys got this one product from this one company that no one had ever heard of to become a household name?
Didn't they take a survey of people who bought the product?
Yeah, they literally took a survey of people who bought the damn product, and they're like, see, it's a household name. They manipulated the community to get the meaning they wanted. You can shrink or expand your community. That's how you change the meaning of words. Don't ever tell the court you're arguing what the meaning is. Tell the court this is the relevant community and this is how they use these words. And you just win, and you can't stop winning. All right? Cool. That's how we're going to do it. The book doesn't give us a great set of, it gives us a great set of cases, but it doesn't give us a great set of methods. And otherwise, we're kind of stuck with this interpretation factor. So let's do Random House. David, would you mind setting up Random House for me, please?
Random House is a book publisher with written agreements with authors Styron, Vonnegut, and Conker. Each agreement stated that Random House had an exclusive right in book form. Both formats each had separate grants and exclusive licenses for reprints and braille editions and something else. In 2000, Rosetta Books signed an agreement with the three authors to publish ebooks under their agreements with Random House and sold the books on their website. Random House then sued Rosetta for copyright infringement in the U.S. District Court. The court decided on whether a right to print, publish, and sell the works in book form contains a grant for ebooks.
Okay.
And Judge Stein said proving infringement required copyright owner, which
Okay. There's a lot to be said about this. Unfortunately, very little of it is about what the meaning of in book form means, which you might think, given that this is our lead case on interpretation, might be what we were doing here. So let's just start real quick. You ask your friend what's the last book they read. And they say something like, I don't know, Johann Hari's Stolen Focus. And then it becomes clear to you that they read it on Kindle. And you're like, yeah, you didn't read that book. Does that cross your mind? Are ebooks books? Okay, all right. By the way, not going down that tangent. Just at the bottom of that well is some serious insight about the nature of reality, right? The idea that a book is entirely socially constructed, that what it means is just how a community uses it. We use this, maybe this is a book, maybe this is a text, this is maybe even probably not a book. It looks like it, but it's arguably not one. Whereas this is probably clearly a book. Why is that the case? And an ebook is absolutely a book. The more that it's, light reading fiction from the airport, the more it's clearly a book. Here's the thing, we're not after what books truly are. Books have about as many definitions as the verb to run. What we're looking for then are the various communities of meaning that are playing games with this. And the reason that I wanted to start with this was to say, are ebooks books? To any human, obviously. So why is that not the outcome of this case?
Well, at the time, they made the contract, ebooks didn't exist.
So at the time they made the contract, ebooks didn't exist, and so it was a new thing, right? All right, look, weird thing. I asked you earlier on in the class, those of you who could, who could see an apple like you're looking at a movie screen behind your eyes, and like who just sees some gray stuff like me. So it turns out I can only see like I'm looking at a movie screen just in the split second as I'm falling asleep, and suddenly it transforms, and suddenly I look around and it's like virtual reality. It's amazing. For just that split second, though, I don't have the superpower many of the rest of you have. Let's imagine there's a technology that lets me use that capacity, just runs a neural adapter through my brain, so that I can watch Braven or whatever as I'm falling asleep. Is that a movie? I see you haven't seen Braven. Jason Momoa, it's a classic. Far northern Alaska, kind of a thriller. If I watch Star Wars through a neural inductor, is it a movie? Yeah. All right, so this is the first problem that we run into. This case is supposed to be about new use cases, new technologies, and the difficulty in coming to terms, interpreting terms as technology advances. Which sounds good for, 30 seconds. Except let me be very, very clear. What do all of the contracts say now? Who wins this? Who wins, who loses? Random House lost. The publisher lost. The publisher, the big powerful publisher, which had the language, we get to put this in book form, lost. Do you think if you write the great American novel and sign it with a publisher, that they will not be able to put it out in ebook form? What does every contract now say? In all forms, actually, they'll add ebook and neural inductor, and because of cases like this crap, they'll also say, and any technology future developed, whether now extant or in the future, and our copyright license extends throughout the known universe. They're not playing games with space travel either. I'm deadly serious. You want to know what the duration is? Perpetual, infinite. All of time, all of space, all of technology. They are so done with this crap. And so, like many contracts cases, I struggle to take the case itself seriously. The points that it raises, I take very seriously. But this case is just mind-bendingly boring because it's a case that happens once and then they write it into all of their contracts and it never happens again. And so, if you look, do not look at this case and be like, oh, okay, yeah, so I've got a contract for books, then I get the ebooks, or I can do the Audible, or I can do the AI LLM, Notebook LLM spin-up podcast version of the book, da-da-da-da. Clearly, new technology, right, won't be written in yet. No, absolutely not. That is not how any of this is going to work. So is there any way of salvaging then what the court's doing with this? What community is the court really looking at here? Do you notice who the plaintiffs, who the other side is? It's Random House versus Rosetta Books, sure. But who's Rosetta Books representing? They're a technology company. Yeah, who are the authors? And we know, and here's the interesting thing, y'all, I don't know a lot of authors out there. Like Isaac Asimov, a few, I'm a science fiction junkie. I'm Sarah J. Maas, I will admit that, that's a problem. Right, so I know a few authors. Who are the authors here? Kurt, and his middle name is Kurt Vonnegut. And, right? right? Sophie's Choice. Okay, y'all. What's going on here? What's going on here?
I like these authors, so I'm going to side with them.
I like these authors, so I'm going to side with them. I think it's more than that. They're big names, which means that this is a different kind of contract. Remember I said if you signed your publication deal, it would have or didn't have certain terms in it, right? But if John Steinbeck or whoever is signing this thing, they're going to have different affordances. Now this matters because who has made, I don't want to say it's the most, but who made the most, what? Author's rights. Who made the most money for the shortest appearance on a screen? I'll just make sound effects until you figure it out. It's the guy who played Ben Kenobi. Why? Yeah, he didn't take a salary for that. He was like, maybe this will go somewhere and maybe it won't. He was a big name at the time. So he took a cut. I think it made him about 90 million in real dollars. We're talking like 1980s dollars. It made about 90 million for about 15 minutes of screen time. He had the ability to negotiate. The problem is this is a different kind of contract. If we're thinking about the kind of contract that you get handed, I agree whenever you upload your creative material to Midjourney or Facebook or whatever. They've got these licenses. They all have these licenses saying, by uploading your material to our site or service, you agree that we have a fully paid, perpetual, non-exclusive license throughout the known universe for all technologies now created or in the future created in order to be able to push your content out on the web. That contract you signed is very different from the contract these authors are signing. Does that context and community shift give meaning then to this? Where I was starting with sort of sarcasm, saying, the next contract will always have this in there. Will the next, I don't know, who's big now? Who wrote Tomorrow, and Tomorrow's really good. Who else? Susan Collins, sure, great. Okay, so go with that. The next major rock star signs this. How's that going to be different from the contract you're going to click I agree on? Yeah, they got lawyers, they've got leverage. You reckon that perpetuity clause is in there? Nah, they're going to have it for, 10 years, 20 years, whatever it takes to publish it out. So that'll be different. They're going to have this throughout the known universe clause in there? Nah, it's going to be no. You get, what? You get the North American rights. Somebody else is going to get, the rights in China, what have you, and so forth. Translation rights, derivative work rights, right? What do we think about then, Suzanne, signing something for, neural induction helmets? Is she going to sign one of these all future technologies clauses? Abso-freaking-lutely not. Why? Because she's expressly reserving the value of those markets for her. What I need you to see is where we started was, are ebooks books? And you're like, yeah, of course they are. Which would mean Random House wins, but that is not the game we are playing because that is not the community and the colloquialism we are drawing on. You have to realize who the court's talking about. And the court's talking about high-end authors that have engaged in specific negotiations for specific markets. And there the rule is, if you didn't negotiate to take that market, you don't get it for free. You see the shift? All we did, words were identical. All we did was we took one community in context and we went whoop, and we moved it to another community in context, and suddenly the case snaps into focus. It's either a profoundly stupid case, which no one should ever read because every contract after this point will immediately put this stuff in book form and ebooks. Come on, Random House, seriously? You make us say this? Fine, right? That becomes a boring case. We flip it. We're like, oh no, we get it. If you've got leverage and you're actually negotiating, authors often want to distribute their intellectual property in a way that's going to maximize their profits, and that makes perfect sense. All right, we're at the end. We've got 2 minutes to spare. Is there any question on Random House? Otherwise, we will take it, and I will see you after quite some time. That's true. The takeaway from this case is contractual interpretation is a matter of community and context. Changing the meaning of words means convincing the court to adopt the meanings used by a different community in a different context. All right, thanks, folks.